Okay. Okay, Mr. Seeger, do you have Ms. Walker?
Yes, Your Honor, Ms. Walker's not here, but I think that's due in part to my error. There was a motion that's been pending, and then we had to change some dates. I don't really remember. I think one of the officers was unavailable. And so there was some correspondence with your clerk wherein I think she had said, I'm going to take that down because originally I think we were going to argue it today. And then we moved it to another date, which the date, I don't specifically recall what date it was, but I had told her that the next date was going to be whatever date the motion was on. So she's not here because she failed to appear. She's here because that's what I had told her.
Okay, Mr. Ziegler?
We have a motion hearing for August 14th, Your Honor. I wasn't expecting anything to happen today, and I don't want to hold anything against Ms. Walker if Mr. Seeger miscommunicated that to her. I know we've been trying to find a date for that motion for a couple weeks, and we've proposed a bunch of different dates, so I understand there might have been some confusion.
Okay, so I'm just going to continue this case till August 14th, looking at that motion hearing. And I won't take any further action on that. Mr. Seeger, I did this morning get the request for Mr. Almy. I don't know if he's here in person.
He's not, Your Honor. He did contact me this morning asking if he could appear by Zoom and if I could again check with the clerk. And I did check with the clerk. The clerk was unsure of whether or not he could appear in that manner. I didn't endorse it. I didn't give him a Zoom code because you didn't endorse it. He's not here because he didn't have a ride. He was having vehicle problems and he was trying to figure out a ride and he wasn't able to get one. In any event, Your Honor, I have been in good contact with him. And we weren't likely to resolve the file today. However, it is my understanding that he's likely to resolve it at the next hearing to the extent that the court continues it to the next date.
Okay, Mr. Ziegler?
Your Honor, I'm a little less impressed with Mr. Almy, given that his issue was just a ride and not miscommunication. He's a habitual four. However, I don't know that he has any history of failing to appear in this case. I would just ask the court to issue a show cause and hopefully he can explain that to the court at the next hearing.
Okay. The other, I guess, issue with Mr. Almy's case is I did get a report indicating that there was a complaint for a bond violation. Mr. Almy was apparently using alcohol as pulled over. He wasn't above the legal limit, so I don't think he was arrested at the time. I don't know if you're in receipt of that, Mr. Ziegler.
I have not received that.
I'm not sure how I got it. It was attached to my documentation for today. So I guess I'm going to provide this to both counsel. I only have one copy. Mr. Ziegler, I'll leave it up to you whether you want to take further action on that with regard to Mr. Almy. Otherwise, I'm going to set this for a plea hearing at the court's next date and a show cause. If Mr. Almy fails to appear for that hearing, the court will issue a warrant for his arrest. Versus Knapp. Give me a Miss Knapp.
Ready, Your Honor.
Miss Knapp, if you'll come forward, please. This is file number 265228. The record should reflect Miss Knapp's present here in the courtroom today. Mr. Seeger, how do we want to proceed on this file?
Yeah, I think that there's a resolution. However, if the court would give us one final action date for us to either accept or reject a plea, I think that the file is likely to be resolved. She did ask me to go back to the prosecuting attorney to ask for perhaps a different variance. I did, prior to discuss her asking me to do that, I did have an opportunity to speak with the prosecuting attorney, for which at least at that time he was uninclined to amend the offer. But be that as it may, Your Honor, if the court gave us an additional 30 days, I'm confident that we'd be able to resolve it at the next date.
Mr. Ziegler?
I don't have any objection to a 30-day adjournment, Your Honor.
Okay. I believe this is Ms. Knapp's first appearance before the circuit court. This matter was just found over recently. I think it's reasonable to allow a little extra time for plea negotiations. So Ms. Knapp, the court's going to set this for a hearing at the beginning of September. You'll get a date and time of that hearing, just as you did for today. Between now and then, it's important that you stay in touch with your attorney and that you're ready with a final decision as to any plea offers on that next date.
Okay,
Do you have any questions at all?
no,
Thank you. That's all for today.
thank you.
We're a little ahead. Mr. Seeger, do you have any other clients?
Ms. Gable is here and Mr. Patrick is here.
Mr. Patrick, if you come forward, please. The court will call People versus Dustin Patrick, file number 265195. The record should reflect Mr. Patrick is present here in the courtroom today. Mr. Seeger, oh, I'm sorry, this is the date and time set for sentencing.
It is, Shane.
Okay. Mr. Patrick, have you had an opportunity to go through the pre-sentence report?
I have.
Okay. Have you had an adequate opportunity to speak with your attorney about that?
I have.
Mr. Seeger, do you have any additions, deletions, or corrections to that report?
No, Your Honor.
Do you have any challenges to the scoring?
I do not. No.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I would simply ask the court to adopt the recommendations. This is the defendant's first felony sentencing. He has 4 prior misdemeanors, no prior felonies. I think he's a good candidate for the 7411 program. I'm hopeful that he will take full advantage of that and be successful if the court decides to give it to him. But otherwise, I would just ask the court to adopt the recommendation.
Thank you, Mr. Seeger.
Your Honor, I tend to agree with Mr. Ziegler. Mr. Patrick has expressed a great deal of want to be successful on his probation. He has also expressed the want to have an opportunity to not have a felony on his record. Because he has no prior felonious history, hopefully that is a very much an incentive for him to successfully complete his probation. He's been in regular contact with me, so I assume that he'll be in regular contact with the probation department. I assume that he'll follow through with the objects of it. He didn't indicate to me that this has been very much a learning lesson for him. He needs to make better decisions, which he indicated that he will going forward. If given the opportunity to be placed on 7411, I have no reason to believe that he will successfully complete it.
Thank you. Mr. Patrick, anything you want to say?
No.
Well, I did read through the report prior to the hearing today, so I'm familiar with all the information in that report, including the circumstances that bring you before the court today, as well as just generally your background and your circumstances as well. And, you know, I guess the thing that struck me about the incident itself is just, you know, how dangerous it is to be riding a motorcycle under the influence of alcohol and cocaine. I mean, you put yourself in a position where, I used to ride, so I get it. Yeah. It's hard enough when you're completely sober.
Yeah.
And so I hope it is kind of a wake up call for you.
Oh, it
Because you don't want to put yourself in that position. You don't want to put yourself in a position where you could hurt someone else by riding in the condition that you were in. I do think that there, you know, based on your prior history and your age, that there is a good chance for rehabilitation here. And so I do think that probation is an appropriate way to address the conduct. I'm not going to impose any upfront jail time. I'm going to hold some jail in advance, hopefully to act as a motivator for you to the extent that you need additional motivation to comply with the probation. The benefit to you to the 7411 probation, as I'm sure you know, is that if you successfully complete it, this comes off your record. That's a huge benefit. And I don't think there's any risk to the community in giving you the opportunity to do that, particularly with your lack of any prior felony history. So I don't see any reason not to agree with the recommendation. So the court is going to place you on probation for a term of 24 months. If you do well on probation, you'd be eligible to have a significant portion of that time reduced, which is another benefit to complying with probation. The court is going to make that probation pursuant to the 7411 statute. I am going to adopt as the conditions of that probation all the terms and conditions listed in this report. And that includes that you comply with any alcohol or drug testing, and that you not use or possess any controlled substances or drug paraphernalia unless they're prescribed to you by a doctor, along with all the other terms and conditions. The court is going to impose 90 days in the Crawford County Jail with third credit for 32 days served, that time to be held in abeyance to be served at the discretion of the court. The court will order a crime victim's assessment of $130, court costs of $325, fine of $325, attorney fees of $350, and a $68 state cost, as well as a supervision fee while you're on probation of $30 per month. Because the probation is pursuant to 7411, there are no appellate rights at this time. Ms. Wagner, would you like Mr. Patrick to stop by the probation office before he leaves court today?
Yes, please. Thank you.
So, Mr. Patrick. Oh, Kalkaska County Jail. I'm sorry. In terms of the jail sentence, of course, that would be Kalkaska, not Crawford. I misspoke. Mr. Patrick, before you leave today, please stop by and meet with Ms. Wagner. Do you have any questions?
I do not.
Good luck to you going forward.
Thank you, sir.
And then, Your Honor, Miss Gable is here.
Okay. Ms. Gable, if you would come forward, please. We'll go on the record in People versus Gable, file number 265214. Record should reflect Ms. Gable's present here in the courtroom today. Mr. Seeger, how did we want to proceed on this trial?
Yeah, she would just ask for one eviction status conference when she's likely to resolve the file. And she was hoping to have an additional period of time, one, to contemplate the offer, and two, to attempt to demonstrate that she's able to be well on bond. So to that end, Your Honor, if the court would give us an additional 30 days, I suspect that we'll be able to resolve it at the next court date.
Mr. Ziegler?
I don't have any objection at this time, Your Honor.
All right, again, this is Ms. Gable's first appearance before the circuit court. Looks like this case was recently bound over. So, Ms. Gable, we will set this for a plea hearing in about 30 days.
Okay.
Between now and then, it's important that you stay in touch with Mr. Seeger and that you're ready with the final decision as to any plea offers at that next hearing. I won't allow any further adjournments in the case. So I'll need you to be ready with the final decision at that time, okay?
Yes, sir.
Do you have any questions at all?
No, sir.
Mr. Seeger, anything further?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
Oh, thank you. That's all for today, Ms. Gable.
And then, Your Honor, the next thing that I have is with the Wexford County Jail, Miss Way.
They are not connected yet. We are a little bit early. So we'll take a brief recess and we'll come back on the record next. Okay, are you, ma'am, can you tell me your name, please?
Way,
Ms.
Amanda
Way.
Way.
Thank you. We're on the record in People versus Amanda Way, file number 265223. The record should reflect that Ms. Way is appearing today by video from Wexford County Jail. And Mr. Seeger, can you address this file for us, please?
Your Honor, an offer has been extended where Ms. Wade could plead to one count of possession of methamphetamine with no habitual offender notice, and all other counts would be dismissed.
Mr. Ziegler.
That's correct, Your Honor. Plead to count one, dismiss the remainder.
Ms. Way, were you able to hear that?
Yes,
And is that the agreement that you've discussed with Mr. Seeger?
yes,
Is that how you wanted to proceed today?
yes,
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, I do.
Thank you. You can lower your hand. Ms. Way, are you currently on any kind of probation or parole?
No,
You understand that by pleading guilty to, I'm sorry, was it count one?
Correct.
Okay, by pleading guilty to count one, that the maximum possible penalty you could face would be up to 10 years and or a $15,000 fine.
yes,
With that in mind, what is your plea to that charge today?
guilty,
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
yes,
Can you tell me what's going to happen to those rights by you pleading guilty?
I'm waiving them.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are actually guilty of this charge?
yes,
The information I have indicates that this happened back on June 8th of this year, 2026. Is that correct?
yes,
At that time, were you present here in Kalkaska County?
yes, I was.
While you were here in Kalkaska County, did you have possession of some methamphetamine?
I did.
Did you know that that's what that substance was?
Yes,
Did you have any legal right to have any amount of it at that time?
no,
Thank you, Mr. Ziegler. Are the people satisfied with the factual basis?
I'm satisfied, Your
Mr. Seeger?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Ms. Way, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from probation will be in touch with you to prepare a pre-sentence report. Mr. Seeger, is there anything further on this file today?
Your Honor, the only addition would be that Ms. Way was hopeful that the court would consider allowing her to be released into treatment to the extent that she can become eligible. She's filled out some forms wherein I think that they were trying to wait to see what was going to happen with this file to determine whether or not she was going to be eligible. But clearly, she does have a substance abuse problem that needs to be addressed, and she was hopeful that she would be able to address it in advance of sentencing as a matter of good faith, just generally showing that she is wanting to maintain her sobriety. Whether or not she's able to or not, I guess that's a different question. She has struggled at times, but I think that this period of incarceration has probably given her a little bit more clarity about what she needs to do going forward.
All right, so Ms. Way, I certainly would consider treatment as part of the sentence.
Okay,
But that's something that I would like to have the pre-sentence report so I can see kind of a little bit more about what happened in this case and your background.
Okay.
Before, I would make a final decision on that. So I'd like to have the sentencing hearing, but I would certainly consider treatment as, an option for sentencing.
okay. Thank you.
Yeah. All right, thank you. That's all for this hearing today. Anybody else at Wexford? Mr. Crevis, do you have anyone who'd like to come? Hey, Mr. Burke. I think not quite up yet. Okay. That's the end of your files, Mr. Steger.
I believe so.
Yes, sir.
Oh, you know what? Actually, he is set for 9:45, so he would be. He's not listed next, but he would be appropriately next.
Do you have anybody that's in the courtroom?
Yes, I do. I have Mr. Burwell who's in the courtroom.
Court calls People versus Robert Burwell, file number 265226. The record should reflect Mr. Burwell is present here in the courtroom. Travis, you can tell me how you think you proceed on that file today.
Yes, Your Honor. We did waive the prelim in this case based on an offer from the prosecutor, and it's my understanding that Mr. Burwell would like to accept that offer.
Okay, can you tell me the terms of that offer?
Yes, my understanding of the offer would be to plead to a 4-year possession of narcotics with no enhancements.
Fair statement, Your Honor.
Okay, Mr. Burwell, is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. Mr. Burwell, are you currently on any probation or parole? Where's that?
I'm going.
And are they aware that you're entering this plea here today?
I believe so.
Okay. Do you know whether that's going to result in a violation of your probation there?
It is not.
Okay.
I've served my violation.
Okay. Then you understand that by pleading guilty to possession of narcotics, that the maximum possible penalty is up to 4 years.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
I do.
And you understand that you're giving up and waiving those rights by pleading guilty.
You're
Also, you don't have an automatic right to appeal the plea that you're making today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that? Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court today?
no.
Is it your own free choice to enter this plea?
Yes,
Are you pleading guilty to this charge because you are actually guilty?
yes,
Back on February 25th of 2026, were you present here in Kalkaska County?
I was.
And at that time, did you have possession of some methamphetamine?
I did.
Did you know that that's what that was?
Yes,
Did you have any legal right to have any amount of it at that time?
no,
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
Your Honor, just so the record's clear, there was a collateral agreement between myself and the defense for some testimony in a different manner, and that was part of the plea negotiation.
Okay, Mr. Travis, is that correct?
It is correct.
Mr. Burwell, you were aware of that?
Yes, Your Honor.
Okay. Does that change anything about your willingness to enter into the plea today?
No, sir.
Mr. Travis, are you aware of any other threats, promises, or inducements?
No.
Counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Burwell, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney between now and then. And Ms. Wagner, did you want Mr. Burwell to stop by the probation office today?
Yes, please, Your Honor. Thank you.
Okay, so before you leave, do you know where the probation office is?
I do not.
It's just if you walk across the way here to the next building, it's right in there and those signs directing you, but please stop in there before you leave. Do you have any questions?
Do not.
Thank you, that's all for today.
Thank you.
It's a tax code.
333.74032A5.
Thank you.
Right there at Wexford County, are you Mr. Burke?
Yes, sir.
We'll go on the record in People versus Jared Burke, file number 265231. The record should reflect Mr. Burke is appearing today by video from Wexford County Jail. Mr. Travis, can you tell me the status of this file today?
Yes, Your Honor. We did waive the prelim in this matter. We have had some recent plea discussions with the prosecutor, and it is my understanding they would offer to resolve this case upon a plea to an attempt felonious assault by Mr. Burke.
One count of attempt and all other counts dismissed.
That's correct, Your Honor.
And the habitual.
Yes, sir. Dismiss.
Mr. Burke, were you able to hear that?
Yes, sir.
Is that the plea that you've discussed with your attorney?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Right. Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Burke, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to assault with a dangerous weapon or felonious assault as an attempt, that the maximum penalty you could face would be up to 2 years and or a $1,000 fine?
Yes, sir.
With that in mind, what is your plea to that charge today?
I'm gonna plead guilty to that.
Okay, right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
Do you understand that you're giving up and waiving those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you have to ask for the Court of Appeals to hear your case. If they were to say no, then you couldn't go any further with that appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've said on the record here today?
No.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates that this incident happened, excuse me, back on June 22nd of 2026. Is that the correct date?
Yes, sir.
All right. On that date, did you have some type of altercation with someone by the last name of Curtis here in Kalkaska County?
Yes, sir.
All right. And did you attempt to make some type of assault on them with a weapon like a rake?
Yes.
Okay. Mr. Ziegler, do you have any additional questions?
I think that satisfies the elements, Your Honor.
Mr. Travis?
I believe it does.
Okay. Counselor, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor. No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Burke, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department will be in touch with you to prepare a pre-sentence report. Travis, is there anything further we need to address on this case today?
Nothing further, Your Honor. Thank you.
Mr. Ziegler?
No, Your Honor.
Okay, thank you, Mr. Burke. That's all for this hearing today.
Sweet.
Mr. Travis, you ready with any other files?
Ms. Spencer is in the courtroom.
Ms. Spencer, if you come forward, please. We'll go on the record in People versus Emma Spencer, file number 265204. The record should reflect Ms. Spencer's present here in the courtroom today. Mr. Proceed on this case.
Your Honor, thank you. We had adjourned from last month for Ms. Spencer and I to talk some more about the facts of the case. It is my understanding she comes here wishing to accept the prosecutor's plea offer, which would be pleading to the count of possession of methamphetamine, but with the understanding that that matter be handled under 7411.
Mr. Ziegler.
Fair statement, Your Honor.
Ms. Spencer, is that the plea agreement that you've discussed with your attorney?
Yes, Your Honor.
All right. And is that how you wanted to proceed?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your
Ms. Spencer, are you currently on any kind of probation or parole? You understand that by pleading guilty to count one, which is possession of methamphetamine, that the maximum possible penalty that you could face would be up to 10 years and or a $15,000 fine.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Your Honor.
Right now, you have certain rights. I know you've heard me go through this with some other folks, but I need to go through them with you individually as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself at a trial if you want it. Do you understand that you have all of those rights?
Yes, Your Honor.
Can you tell me what will happen to those rights by you pleading guilty?
I will no longer have them.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, which means you have to ask the higher court, the Court of Appeals, to hear your case. And if they say no, that's the end of the appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today? Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
This happened back on August 26th, a while ago, almost a year ago. Is that correct? Okay, 2025. At that time, were you present here in Kalkaska County?
Yes. Yes.
Did you have possession of some methamphetamine?
Yes.
Did you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
No, Your Honor.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor. Yes, Your Honor.
Thank you. Ms. Spencer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing.
Thank you, Your Honor.
It's important that you stay in touch with Mr. Travis between now and then. And then before you leave today, you need to stop at the probation office next door. Meet with Ms. Wagner to set up a time for the pre-sentence report. Do you have any questions?
Thank you, Your Honor.
Okay, thank you. That's all for today. Okay.
Mr. Robinson, he's set for a couple minutes from now, but he's up from Wexford County.
Okay. Mr. Robinson, are you able to hear me okay?
Yes, sir.
Okay, we'll go on the record in People versus Brian Robinson. This is file number 265218. The record should reflect Mr. Robinson is present today by video from Wexford County Jail. Mr. Travis.
Thank you, Your Honor. Your Honor, this, we did hold a prelim in this matter. This is Mr. Robinson's first appearance in circuit court. We would be asking for a 30-day adjournment. That is because in speaking with Mr. Robinson and Mr. Elhart, they are in discussions for Mr. Robinson to hire Mr. Elhart, and they have both confirmed that. It hasn't happened yet, but that was their joint request that we asked for time for that to happen.
Okay. Mr. Ziegler.
I don't have any objection at this time, Your Honor.
All right, Mr. Robinson, were you able to hear all of that?
Yes, sir, it was.
Is that correct? You'd like the court to reset this to give you an opportunity to hire Mr. Elhart?
Yes, sir, please.
Okay. Is 30 days enough time for that, Mr. Travis?
I believe so. When I discussed the prospect with Mr. Robinson, and then I think last Friday I ran into Mr. Elhart in court, and he confirmed. And basically, when I said, "Oh, I'll ask for 30 days," then he said yes. So it seemingly is.
Okay. All right. So, Mr. Robinson, the court's going to set this for another hearing, and at that point, we'll need to go forward. Do you believe that you'll be able to have Mr. Elhart hired by that time?
Yes, sir, probably within the week.
Okay. All right. Do you have any questions, Mr. Robinson?
No, sir, thank you.
Anything further, Mr. Travis?
Nothing further on.
Thank you, Mr. Ziegler.
No, Your Honor.
Okay, thank you. That's all for today, Mr. Robinson. We're going to disconnect from your case.
Yes, sir, thank you.
Is Mr. Willoughby lodged somewhere, or is he?
I think he's ready to appear by Zoom from MDOC.
Okay.
And if I could, Your Honor, get a breakout room with him to chat with him for a minute.
Yes. If you want to go ahead and sign in, I don't see them yet.
Where's your-
We'll take a short break. Okay, Mr. Willoughby, if you could go to the podium there, please, and we'll go on the record. Will versus Willoughby, file number 244988. The record should reflect Mr. Willoughby's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Willoughby.
Okay. And Mr. Willoughby, I believe we're here for purposes of a probation violation. Is that right, Mr. Travis?
That is correct, Your Honor.
How did we want to proceed on that today?
Your Honor, it's my understanding that we've got an agreement with probation that he would plead to allegation number 3, which is basically violating the criminal law by drinking and driving in a matter in Grand Traverse County.
Okay, Ms. Wagner, is that a correct statement? You plead guilty to the non-technical?
That is correct, Your Honor. Thank you.
Okay, Mr. Willoughby, have you had a chance to speak with your attorney about this?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Willoughby, you understand that you would have the right to have a hearing as to whether or not you violated your probation.
Yeah.
You understand that by pleading guilty, you're going to be giving up that right.
Yes, sir.
Also, by pleading guilty, it could subject you to the maximum possible penalty on your underlying charge, which is felonious assault. That's a 4-year felony. Do you understand that?
Yes, sir.
With all of those things in mind, what is your plea to the violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything?
No, sir.
Is it your own free choice?
Yes, sir.
Are you pleading guilty because you did violate your probation?
Yes, sir.
On or about September 19th of 2025, were you on probation out of Kalkaska County?
Yes, sir.
Were you aware that one of the conditions of your probation was that you were to not violate any criminal laws of the state of Michigan?
Yes, sir.
And did you violate a criminal law by operating a vehicle while under the influence of alcohol?
Yes, sir.
Thank you. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that there was a violation of probation. The court will accept the guilty plea. Ms. Wagner, it looks like your recommendation is simply to preserve any fines and costs and revoke and discharge unsuccessfully. Is that correct?
It is correct, Your Honor. He is already serving a prison term out of Grand Traverse County for a new felony offense, and he does have pending outstanding criminal matters on Otsego County where he'll probably face some more consequences on that.
Okay. Mr. Travis, anything on behalf of Mr. Willoughby today?
Thank you, Your Honor. Just that I believe he's been incarcerated. I think this warrant was authorized on September 19th of 2025, and I believe he's been incarcerated actually even since before then on this, Your Honor. So we would ask the court to follow probation's recommendations and discharge him unsuccessfully from HIDA and sentence him to time served.
All right. Ms. Wagner, do you have a jail credit amount? You're muted.
Sorry, I don't. I'd have to go back and refigure that because he's been under sentence under Grand Traverse County, so he wouldn't be accumulating any time on this matter since he's already under sentence.
Okay, is that something that you can provide to Christy here before the end of the day?
Yes.
Okay. All right, Mr. Willoughby, was there anything you wanted to say today?
No, sir.
All right, I did have a chance to review your file prior to the hearing today. Based on the plea and your other circumstances, I think that the recommendation is appropriate. The court is going to follow that recommendation. The court will discharge you unsuccessfully from your probation in this case. The court will revoke your HIDA status. The court will order that any outstanding fines and costs be preserved for collection. You do have the ability to seek an appeal of this sentence. Deputy, can you provide that paper to Mr. Travis? Mr. Willoughby, these papers will explain how to appeal the sentence and how to request a court-appointed attorney to help you with any appeal. And then for the record, the court will sentence Mr. Willoughby to time served. And that number will be added to the judgment sentence once it's provided to the clerk.
Thank you, Your Honor.
Thank you. That's all for today, Mr. Willoughby. Thank you.
Yeah, since we've handled Mr. Robinson, I think that's the end of my docket.
Is counsel ready on Mr. Schilling's matter?
We are, Your Honor. Defenses anyways.
I'm ready, Your Honor.
All right. Go on the record in People versus Jonathan Schilling, file number 25522. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
And good morning, Your Honor. Attorney Jeff McCarty, P42633, with behalf of Mr. Schilling. If you could please state your name for the record.
Jonathan Schilling, Your Honor.
All right, thank you. We're on the record here today for purposes of a hearing on defendant's motion to quash. I did get your motion. Mr. McCarty, I had a chance to review that motion as well as the preliminary exam transcript. Mr. Ziegler, I did get your response. I had a chance to review that as well. So, Mr. McCarty, anything by way of oral argument that you want to present to the court?
Yes, Judge, and I appreciate the notation that Your Honor had the opportunity to review the transcript. There's also an exhibit that was introduced at the preliminary examination, that is Deputy Ferrier's body-worn cam, which captures this entire incident on video and audio, I might add. So we don't necessarily have to take my word for anything or Mr. Ziegler's word for anything. It's all there. Everything is captured on video. And just by way of somewhat brief reply to the response to my motion, Mr. Ziegler indicates that Deputy Ferrier never made any orders relative to my client and his home. It's very obvious from reviewing the body-wear camera that he ordered both my client and his son out of the mobile home they were in. I'm pulling you both out. And that was in regards to investigating a call, a 911 call of a neighbor indicating she overheard a woman needing help. Please call 911. So Deputy Ferrier was there to investigate that circumstance. Pulled my client's son out of the house first, came out hands up, barefoot, dressed only in shorts, no shirt, came out like this. My client responded shortly thereafter. He was similarly dressed. He had sweatpants on and bare feet and a t-shirt, hands up. Was a little bit incredulous as to why he was being pulled out. Nonetheless, complied. Then I think what's noteworthy as it relates to the people's response at the 3-minute mark of the body-wear camera, that is an exhibit at the preliminary exam, my client turned and went back in his home. Nothing was said by Deputy Ferrier. Who knows what he could have been accessing again, but he came back out and complied with the investigation. Allowed his son to speak with Deputy Ferrier. He spoke with Deputy Ferrier, told him there's no woman here, there's no female here. My mom was here, she left. We had an argument over my grandfather's recent passing, but nobody is here. Gave him his full name, his date of birth, his last four of the Social Security, did everything he could to comply with and answer the deputy's questions as to the suspicion that brought him there relative to this 911 call. At some point, after he had told them everything that he knew, he went to go back in his house. Deputy Ferrier did stop him and says, no, we're not done here. My client said, okay, I'd like you to speak with my sergeant. At that point, Sergeant Schwab had made the scene and got on the porch. He began talking with my client as well. So there's 2 armed officers, Deputy Ferrier and Sergeant Schwab, on the porch with my client and his teenage son, I believe he's 17 or thereabouts. I believe he may even be in attendance this morning. But in any event, sat down and tried to answer all their questions, again, to the extent that they're there to investigate the need for a woman in distress or needing help. There's no woman there. I don't know what it is that they were investigating thereafter, but they remain. Okay, at some point, my client took a seat, of various points, took a seat on his own front porch and sat there while Deputy Ferrier questioned his son. By this time, another deputy had arrived, Deputy Devino, and he was flanked to my client's right. So there was 3 armed officers. My client seated barefoot with sweatpants and a t-shirt, and looming over him was Sergeant Schwab, a big individual. I would estimate, based upon the body wear cam, in the neighborhood of 250 pounds, standing over my client, armed with a gun. Thereabouts, my client's mother made the scene, came back, as it were. Deputy Devino went to question Miss Schilling. So we've got one deputy questioning the mother, another deputy questioning the son, and Sergeant Schwab standing over my client, seated on his own front porch. Now, at some point, he was asked to stand up, turn around, put your hands behind your back. Now, the prosecution would have you believe, variously, I might add, that 1, it was for the officer's safety, and 2, perhaps to secure the scene. And I would submit, based upon my brief and the case law that I've cited in there, that neither one of those circumstances were present in this case. There was no officer safety. He'd like you to believe that because that would give rise to a handcuffing. Certainly you can handcuff individuals that you detain. But in this case, there was no indication that my client presented a danger to these officers, threatened these officers, came at these officers, were armed. Nothing to that effect. In fact, as you've indicated, you read the preliminary exam transcript, Deputy Ferrier said he did not fear for his safety. And yet, the prosecution wants you to believe that that's why my client was handcuffed. Now, I submit to Your Honor, to this court, that when the command was given to stand up, turn around, and put your hands behind your back, that transformed this detention into a de facto arrest. That is a typical arrest command. Stand up, turn around, put your hands behind your back. With every indication, as testified to at the exam, that then therefore they were going to remove him from his front porch and put him in the back seat of Sergeant Schwab's cruiser. That is an arrest. They can call it whatever they want. They can call it a detention all day long, and they have in their response. But the law says at that moment it transformed that detention into an arrest. They have not rebutted my law. They've not even mentioned it. They've not even attempted to distinguish it. Instead, they cited the case of People versus Green, saying in some cases it's necessary to handcuff a detainee. Well, yes, absolutely, 100%. But not in this case. Not on this record. Not as was testified to at the examination, and not as borne out by the body wear cam, which was an exhibit introduced and received at the examination. None of those facts were articulated. None of those facts were testified to. There was no officer safety concern. He had 3 officers, all of them armed, 3 squad cars with my client seated on his front porch, barefoot, in sweats and a t-shirt. But yet the people want you to apparently follow the dictates of People versus Green. And People versus Green is found at 260 Mishat 392. It is a 2004 published Court of Opinion case, Court of Appeals rather. And let me just quote from a section of the basic facts of People versus Green. Quote, as the police officers approached defendant, he appeared to be preparing for a fight, then became belligerent and approached a female officer with clenched fists. after momentarily following instructions to place his hands on the trunk of the vehicle, defendant pushed away, then turned towards the officer. Then, as a result, he was handcuffed. Certainly, under those facts, under those circumstances, I understand why a detainee would be handcuffed, but not in this case. He was handcuffed, as the court would learn by reviewing the body wear cam, as per Sergeant Schwab, as part of our investigation. I don't know how handcuffing Mr. Schilling would advance their investigation when their investigation up to that point had concluded that there was no female present. What more could they possibly be investigating? But they certainly weren't doing so for officer safety. That's not borne out by the record. It's in the people's response, but unfortunately, not in the exam transcript nor the body wear cam. As far as securing the scene, which the prosecution, I guess, concluded with in their response, that he was handcuffed to secure that scene, there was 3 armed police officers, law enforcement officers. That scene had already been secured. They were simply interviewing Ms. Schilling. Unfortunately, when they showed the use of force with handcuffs, that they commanded my client to stand up, turn around, put your hands behind your back. That was unlawful as it relates to these facts. That was not a lawful command. That was a de facto arrest. And under Marino, he has every right to resist that arrest. He didn't resist that arrest, as you can see on the body wear cam. He got up and turned around, put his hands behind his back, but didn't do so fast enough, apparently, according to Deputy Ferrier. Regardless of the speed at which my client complied with his command, it was not a lawful command, and the people need to show a lawful command in order to have this matter bound over. And the fact of the matter is, and the record of this case, the preliminary exam transcript and the body wear camera do not bear that out. There was no concern for officer safety. There was people's response in that regard is simply not supported by the facts. And for all those reasons, Judge, I'd ask that the matter be quashed and the charge be dismissed against my client. Thank you.
Thank you, Mr. Ziegler.
Largely, I would rely on my briefing, but there's a couple things Mr. McCarty said during his oral argument that I just want to push back on. Number one, he said multiple times that Deputy Ferrier pulled the defendant and his son out of the house. I just want to make clear there was no physical anything by Deputy Ferrier to get these individuals to come out of the house. Deputy Ferrier approaches the house, he knocks. At some point, he opens the door, standing outside of the threshold of the doorway, and he says for someone to come to the door and talk to him. And eventually, during a brief conversation at the door, Deputy Ferrier says, "Do you want to step outside?" or something like that. And the defendant says, "This is a problem if I step outside." Deputy Ferrier says, "No." They step outside. Deputy Ferrier does not put his hands on anyone until such time as the defendant says, "I'm done," gets up and attempts to go back inside the residence, at which point Deputy Ferrier puts his hand on his chest and says, "No, we're not done. You're not free to leave. Take a seat." So there was no pulling of any kind. Defense counsel also wants to make a big deal about how the officers were armed with weapons. Of course, the officers are armed with weapons. Every officer is armed with a weapon at any traffic stop, at any detention, at any kind of interaction with the public. The fact that they were armed doesn't really change the analysis at all. At no point did any officer, to my knowledge, ever draw or display or threaten to use any kind of weapon, firearm or otherwise, against the defendant. Defense counsel wants to say that this was transformed into an arrest at the moment they gave the command for him to stand up and turn around and put his hands behind his back. This is belied by a couple of points. First and foremost, Sergeant Schaub made it clear multiple times that he was being detained. They had a conversation while the defendant continued to be seated and was being told to stand up. Sergeant Schaub must have said at least 3 or 4 times, "You're being detained in furtherance of our investigation." He said a number of times after the defendant stood up or was assisted up by officers when he refused to comply and they eventually cuffed him. As they're walking back to the cars, the defendant even says, "Why am I being detained? Why am I being detained?" Even the defendant understood that this was a detention, not an arrest. And the defendant has police experience. He was an officer with the state police in his past, so he understands that there's a difference between a detention and an arrest. The standard for an arrest is whether a reasonable person in that circumstance would feel free to leave. The defendant knows that sometimes when police are doing an investigation, they detain individuals at the scene for officer safety and to control the scene. So the defendant would not have understood this to be an arrest. And in fact, his statements to police evidence that he did understand it as a detention. Defense counsel says, what more could they be investigating at that point? Well, there's a number of things that they were still wanting to do. They wanted to speak to the son alone. It's true they had spoken to the son, but both the son and the father were on the porch for the entire conversation at that point. And at some point, the defendant told the officers, "I'm done. I don't want to talk to you anymore. Get off my property. You're not doing anything else." Officers still had to continue to investigate this potential domestic violence. They wanted to speak to the son alone. The father was making that impossible for them to do. Also, at the time that they were giving these commands to the defendant, a female had returned to the property, the mother, who came back to the property and who was speaking to Deputy Deveneaux a little ways off the porch on the driveway. She had returned, and obviously officers wanted to speak to her outside the presence of the defendant as well. So there was an ongoing investigation. The officers had a continuing need to be present and to pursue this investigation. The idea that there was nothing more for them to do and they had already gotten all their questions answered, it's simply not the case, Your Honor. So I would ask the court to find a reasonable juror could certainly rule that this was a lawful command in furtherance of their investigation for the defendant to stand up and go to a different location so that they could continue their investigation unimpeded. Thank you.
Thank you.
Just ever so briefly, Judge, unfortunately, that's just not what the law is. And when somebody's transported from his front porch and placed in the back of a cruiser, I don't know how with a straight face the government can stand up and say that person is not free to go, or they wouldn't consider themselves not free to leave. That is an arrest. It doesn't matter what my client called it. I don't believe he called it a detention. I believe he says, why am I being arrested? Because that's exactly what happened. And frankly, Judge, Sergeant Schwab could say a half a dozen times, a dozen times or more, you're being detained. You're being detained. That doesn't make it a detention. It doesn't change the fact of a de facto arrest into a detention just because he says it so. He was being detained. That's the irony of this whole case. As he sat there on his porch, he was being detained. Deputy Deveneaux was off questioning the mom. If Deputy Ferrier wanted to question the son around the corner in the house, he could have done so. I think that's a red herring. My client was being detained. What changed the detention was Sergeant Schwab's insistence, and apparently, according to the information his Sergeant Deputy Ferrier, by the command, stand up, turn around, put your hands behind your back. That transformed everything into this investigation, into that detention. It already was a detention, into a de facto arrest. That was without probable cause. That was an unlawful command as it relates to these facts. And not only does the exam transcript bear that out, but the body wear cam. I don't know how counsel can stand up here and say that Deputy Ferrier did not tell my client, "I'm pulling you both out." Of course, I don't mean in a literal sense, but that's an order to leave his home and come out on the porch and talk with him, which he did. For all those reasons, Judge, I ask this court grant my motion.
Okay, all right, thank you. So again, I had a chance to review all the materials prior to the hearing today. First of all, with regard to the motion to quash, the court reviews the determinations of the district court, the factual determinations of the district court, and bind over under a standard of an abuse of discretion. That is, as long as the decision is within the range of reasonable and principled outcomes, the court will uphold the district court's decision, recognizing that there may be any number of correct conclusions to draw in any particular situation. This court would not substitute its judgment for that of the lower court. The lower court's decisions of law are reviewed by this court de novo. In other words, this court makes its own determinations about the legal findings of the lower court on a bind over decision. The lower court found that there was probable cause. The elements are a knowing failure to comply with a lawful command for, in this case, in the resisting or obstructing. And so looking at the transcript, the testimony of the officer, the video, the court finds, regardless of what my determination may have been, that there was sufficient evidence for the district court to conclude that those elements had been met. I think when looking at both questions here, not only the motion to quash, but the motion to dismiss for lack of probable cause, it's important to recognize the overall circumstances here. We're dealing with police officers responding to a potential domestic violence complaint where a female, the information they had when arriving on scene was that a female was screaming and asking somebody to call for 911. There are multiple individuals present within the residence. There's no female there, but officers don't know whether the female is actually there or not. They're trying to determine what is going on. And again, I think it's important to recognize that this is an investigation into a domestic violence, which are frequently fluid type investigations. Individuals change stories. The facts between when a call is made and the officers are dispatched can change dramatically by the time the officers get there. There are heightened emotions on all the people involved. There are frequently circumstances where other individuals who are present, where pressure is brought to bear on them. You know, in the case where you've got, as we have here, father and son, I think it's reasonable for police to want to interview those people separately, as they frequently do, I think, in domestic violence situations, because stories may be different outside the presence of other individuals. So I think it's, again, important to recognize the nature of the investigation here when looking at the actions of the officers. And so, and look at the actions of the defendant during the course of his interactions, which I think counsel tends to downplay, I think, a little bit in terms of what the officers were presented with in Mr. Schilling's behavior. And taking all of those things together and in context and looking at this as the officers were seeing it at the time, the court finds that there was sufficient cause for them to detain Mr. Schilling. It's apparent to me that he was engaging in actions that were hindering their investigation, making it more difficult for them to do the questioning that they needed to do to determine whether there was something going on or not. And that their action in detaining him and eventually seeking to handcuff him and potentially place him in the back of the patrol car so that they could continue their investigation in light of his actions, that they had proper cause to do that, that it didn't transform it into an actual arrest at the time. And so that they were lawful commands. And then when Mr. Schilling resisted that, which I think is a question of fact for the jury. Again, I'm looking at this under a probable cause standard. I think a reasonable jury can conclude that that was resistance to a lawful order. Other jurors may not. And I think counsel may be able to make very effective arguments to a jury under a beyond a reasonable doubt standard, given the nature of the interaction. But the court finds that there was proper cause for the officers to want to secure Mr. Schilling. I think there's a question of fact as to whether or not his actions were resistance to those lawful commands. And again, that's a matter for the jury to decide. But as the court sits here, both as a reviewing court on the motion to quash and the factual basis for the bind over, as well as the legal question of whether there was a lawful command, the court will deny both motions for the reasons I've stated. And Mr. Riccardi would request that you prepare an order reflecting the order.
You know, I can do that, Judge. At this juncture, I would ask the court to entertain a stay of proceedings so that we can present this matter to the Court of Appeals. I think it's important enough before we go through the mechanics of a jury trial to get a clear ruling from a higher court relative to whether this was a lawful command. And I ask the court to stay for us to consider that.
Ziegler, are you prepared to make an argument on that today?
Your Honor, I guess what I don't want to have happen is go through a jury trial and then this issue is overturned. So I would, if the appeal is actually going to be filed, this is not a situation where the defendant's in custody or is waiving his right to a speedy trial by virtue of filing the appeal. So I don't have a particular objection to some adjournment, but I don't want to kick this out, months or years while we're waiting for an appellate decision. It's a relatively minor case at the end of the day. So I don't have an objection to them filing the application and seeing where it goes.
And Judge, may I, we have a jury status conference of September 9th. Maybe it would be prudent to keep that date and have a discussion occur between myself and my client as to what he would like to do in this regard in light of Your Honor's ruling. At that point, either we could come back and we'd have an application ready to fire off and then reassert a need for a stay. I'd only add that I believe I brought it to this court's attention, and maybe the court got out in front of me, that September 25th date that was scheduled for a jury trial does not work for me in any event. So I don't know if that's something that we need to discuss now or reserve for the 9th, or how Your Honor wanted to proceed.
Okay, what I would suggest, Mr. McCarty, is we proceed as you indicated with the status conference in September. If you would like the court to stay this action pending appeal, I would just ask that you file a motion and notice it for a hearing on that September date, and then we can address it at that time.
Very well. And as far as the trial date, I just want to give everybody as much notice as possible that I can't make the 25th in any event.
Let me just take a look here. I don't have the trial calendar in front of me. And I don't know if that's stacked with other trials. Do you know, Mr. Ziegler, do you have your trial calendar?
Not off the top of my head, Your Honor, no.
Great. Between now and the September hearing, Mr. McCarty, if you can just, have you notified Jennifer?
I'd like to think I have, but I can double check that. I just wanted to give, particularly Mr. Ziegler, as much heads up as possible that I will be in Alaska on September 25th. So I mean,
There is one other trial set for that date, Your Honor.
Okay, so that's fine. So
and
frequently I stack trials for this circumstance, so
well, I
you have an objection to adjourning that trial date?
I don't if defense counsel is going to be out of the state, Your Honor.
Okay.
And so we'll work towards that September 9th date and get together, decide what we want to do. And I'll reach out to Mr. Ziegler as soon as I get a better understanding.
Okay, so three things, Mr. McCarty. First, if you can do an order reflecting the ruling today, and either submit that with a stipulation as to form or under the 7-day rule. Two, if you are going to request a stay, file a motion and set that for hearing on that September date that we have for the status conference. And then three, because Mr. Ziegler doesn't object, I don't have an objection, a stipulation in order adjourning the trial date of September 25th.
Thank you, Judge. Will do.
Okay, thank you.
Appreciate it.
Your Honor, may I ask, can I address the court for a second? I'm just,
I'll ask your lawyer first,
Yes, sir.
if he wants you to. I don't know.
I'm being charged with felony resisting based on what was that? Felony? I can counsel my client was, I was just confused with the nature of the charges.
I don't know what would cause my client to be confused as to the nature of the charges. I think he's just at a loss as to how this is a felony charge, but I can counsel him in that regard.
Okay.
Thank you.
Okay.
Thank you, John.
Mr. Ziegler, are you ready with Mr. Wilkie's case?
I'm ready, Your Honor. I don't know if Mr. Wilkie's.
Is that your option?
Yeah, that's it. Yeah, each of those.
All right, Mr. Wilkie there in Wexford, I'm going to need you to unmute, please.
Okay.
Okay.
Yes.
Okay. So we'll go on the record and versus Kenneth Wilkie. We have three files: 265180, 265221, and 265222. The record should reflect Mr. Wilkie is present today by video from Wexford County Jail. We have Mr. Ziegler on behalf of the people present here in court today. And Mr. Wilkie, you do not have an attorney, is that correct?
No, I have an attorney. It's Damian Nunzio.
All right. No lawyer has made an appearance on your behalf. Do you have record of any lawyer, Mr.
I have not received any appearances, Your Honor.
Mr. Wilkie, no lawyer's made an appearance on your behalf in any of these cases.
Well, I don't know. I'll have to get a hold of him, I guess.
All right. What do you want to do today? I mean, you don't have a lawyer present on your behalf, and I've already adjourned these cases, I believe a few times on the lawyer issue. So I'm not going to keep just adjourning the case and adjourning these cases. So I'm gonna set these matters for trial. If you don't have, what's your lawyer's name again, you said?
Damian Nunzio.
If you don't have Mr. Nunzio, are you going to be requesting a court-appointed attorney?
Yes.
Yes?
Yes.
Okay. All right. Then the court is going to refer these files to the Indigent Defense Administrator, Mr. Seeger, for appointment of counsel. If in the meantime, Mr. Wilkie, your attorney does make an appearance on your behalf, then that won't matter. And if he doesn't, then we'll have the ability to move forward with your files. Mr. Ziegler, do you have any objection to that action by the court?
I don't, Your Honor. No.
Right. Mr. Ziegler, is there anything that you wanted to put on the record today?
Your Honor, just that you're going to set a new status conference for the MIDC attorney, and we're not going to set trial dates today.
Correct.
That's fine, Your Honor.
Yeah. So, Mr. Wilkie, that's how we're going to proceed on your case. The court's going to have you referred to for appointment of counsel. And then you'll have an opportunity to meet with that lawyer before the next hearing. Again, if in the meantime, Mr. Nunzio files an appearance on your behalf, then he can take over the case. But at this point, you need to be represented so we can move forward. Do you have any questions about that?
Well, who's you appointing to represent me?
I don't know. That's not going to be my decision. That gets referred to the Indigent Defense Commission, our local administrator, who will appoint an attorney for you.
Okay.
Did you have any other questions?
No.
Okay. All right. Thank you. That's for all for this hearing today. And we'll move forward once you have counsel at the next hearing. Last hearing in the morning is at 11:15, so we'll take a short recess until that time.
Hello? Is there anybody there?
We are, just hold on 1 second. You're coming through in the courtroom.
Oh,
Judge is on the
okay.
bench.
All right, I'll just sit here then. Oh, I see you guys now.
All right, Mr. Grabda, are you able to hear me okay?
Yes, sir.
We're on the record in your case right now. Deputy, can you hand me Mr. Grabda's file? Mr. Executive Counsel, put your appearances on me.
Ryan Ziegler on behalf of the people, Your Honor.
Michael Horowitz on behalf of Mr. Grabda.
Be a red one. Okay. But if you don't know the clerk says this,
Probably a different one.
Yeah. Just to make sure. I didn't that makes sense, but she was a lawyer.
Yeah.
She was a lawyer. So I don't know what she did here. What's the name?
Yeah. Yes. Forget to go.
I think it's underneath that. There. Okay, Mr. Horowitz, how did we want to proceed on this one?
Good morning, Your Honor. The people have offered Mr. Grabda a plea agreement where he would enter a plea to a reduced count of stalking, which is a misdemeanor. And the people would be dismissing the felony. Mr. Grabda wishes to accept that plea bargain and wishes to enter a plea to that.
All right. Is that a correct statement of the offer, Mr. Ziegler?
It is, Your Honor.
And is that a 93-day misdemeanor?
So
Or
it's a 1 year
1 year.
misdemeanor and or $1,000 fine, Your Honor, and up to 5 years of probation.
Thank you. All right, Mr. Grabda, were you able to hear that?
Yes, sir.
Is that the plea agreement that you've discussed with your attorney?
Yes, sir.
And is that how you wanted to proceed today?
Yes, sir.
All right, can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand.
Thank you.
Mr. Grabda, are you currently on any kind of probation or parole?
No. No, sir.
All right. And as Mr. Ziegler indicated, the maximum possible penalty for this charge, which is stalking, would be up to 1 year and or a $1,000 fine and 5 years of probation. Do you understand that?
Yes, sir.
With that in mind, what is your plea to that charge today?
I'm going to plead guilty on this, the plea offer.
Okay. So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. And that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anybody promised you anything to get you to plead guilty today other than what we've talked about here on the record?
No, everything is just the way you said, yeah, it's all good.
All right. Has anybody threatened you with anything to get you to plead guilty?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
Okay. Mr. Horowitz, would you be able to take some testimony from your client?
Sure.
Okay, thank you.
Mr. Graff, I'm going to ask you some questions about the charge that you're pleading guilty to, and the judge is going to use that testimony to determine whether there's a factual basis for the plea. We discussed that earlier this morning. You remember that?
Yes.
Okay. And we discussed what you were pleading to, correct?
Yes.
And we discussed generally the elements of that offense. We read the statutory language together. You remember that?
Yes.
Okay, so on this day in question, I don't have the date in front of me, but you had contact with somebody that there was a no contact order with at the Sarah dealership in Kalkaska. Is that correct?
Yes.
And that was in Kalkaska County?
Yes, sir.
And there was a no contact order with that person because there was another misdemeanor case involving that person. Is that correct?
Yes, sir.
Okay. And on that day, you saw that person, I guess, navigating around the neighborhood and going through that Sarah dealership.
Yes.
And you approached that individual while you were on an electric bicycle or scooter.
Yes.
And did you then proceed to have repeated contacts with that person over the course of, several, I don't know, minutes, some period of time, had repeated contacts with him?
Yes.
What was that individual's name?
Dave Magley.
Okay. And those contacts were not friendly or consensual contacts with Mr. Bagley, right?
Right.
And you agree that somebody in Mr. Magley's position could feel intimidated or threatened by those contacts, correct?
Yes.
I believe that's sufficient. Thank you, Judge.
Okay, Mr. Grabda, did that happen around May 30th of 2026? Does that sound like the right time frame?
Yes, it does, sir.
Thank you. Mr. Ziegler, are you satisfied with the factual basis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
There's no other inducements or threats or promises that award.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sure.
Thank you. Mr. Grabda, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for sentencing on a separate date. You'll be notified of the date and time of that sentencing. Ms. Wagner, I would request a misdemeanor PSI just so that I have a better understanding of the background facts on this matter.
I think we have to. Are you
Mr.
there?
Horowitz, anything there today?
No, Your Honor. Other than there was a preliminary examination, so there may be some additional context out there that's not contained in the police report.
Okay. Mr. Ziegler?
Nothing further for today, Your Honor.
Mr. Grabda, do you have any questions?
No, sir, I don't.
Okay. All right. Thank you. That's all for this hearing today, and the court's going to disconnect at this time.
Thank you, Mr.
Okay,
Grabda. We'll
thank you.
talk.
That also concludes the court.